Hello all. Thank you for being here. It's wonderful to have you. I believe there'll probably be a few more folks coming in the next few minutes, but I wanted to get us started so we can get into this important discussion. I'm Aaron Mercer. I'm the Vice President of Government Relations with the National Religious Broadcasters. We appreciate you taking time out of your afternoon to be here. Please, also, there's food and coffee here if you'd like any. I know that's helpful in the afternoon. We have a great panel here today and a very interesting discussion, and I hope you enjoy it on regarding free speech versus the free market on the internet. What do we do in that discussion? I believe this is going to be an important topic today and in the years ahead, and our panel will talk about that some more. But I wanted to introduce you to a few folks first, both on our staff and also, first of all, I wanted to introduce Jackie Pick, who is she's the counsel and deputy chief of staff to Congressman Trent Franks. He's the chairman of the Constitution Subcommittee on the House Judiciary Committee. Jackie's here today. She's here as the counsel for Congressman Franks, and we are very grateful that she and her office helped us get this wonderful room. So thank you very much for that. And Jackie, who graduated from Vanderbilt University School of Law, after that she came here and she's been a counsel here on Capitol Hill for about 6 years. And her portfolio includes constitutional law, civil rights, civil liberties, religious freedom, as well as oversight over the Department of Justice and the Department of Homeland Security. But she is a perfect fit to get our conversation started here and give us a congressional staffer's overview of this issue. So thank you, Jackie, for being here. I appreciate it.
Good afternoon and welcome. I want to thank the National Religious Broadcasters, and specifically Aaron Mercer and Craig Parshall, for hosting this timely forum to examine the tension between free speech and free enterprise. This panel is long overdue, and we've been struggling with this issue for far longer than you might imagine. I've been here for 6 years, and I've been hearing about these issues for all of that time. Before I begin, I have to be very clear that I'm here today in my capacity as personal counsel to Congressman Franks, who is both the chairman of the Subcommittee on the Constitution of the House Judiciary Committee and the co-chair of the Religious Freedom Task Force. The tension between free speech and free enterprise is complicated, and I'm going to leave it primarily to the panelists to flesh out the fine legal and policy points, but I'm going to give you the vantage point of a staffer on Capitol Hill. On one side, we have the American-based new media companies such as Facebook, Google, Apple, Verizon, Twitter, etc. And they are before my committee frequently for all kinds of reasons, whether we're trying to protect patents, copyrights, trademarks, free speech. Technology in general is regulated in large part by the committee. So I know all of the folks in those companies through other capacities unrelated to this issue. These companies lead the world in the advancement of technology for worldwide communication, and one could faithfully argue that no group has done more to increase the free exercise of free speech worldwide than the American new media giants. And many Christian and conservative and otherwise religious groups have benefited from these new media platforms. As we all know, nearly every American can say that their lives have been improved in one way or another because of new media. So, to be clear, I'm not unkind or unfriendly to new media. We're looking for ways to solve a very delicate problem. And by the way, we're always glad when America takes the lead in the things that they work on. On the other side of today's issues, we have groups like the National Religious Broadcasters and their members who embody the principles of the First Amendment as much as any group could. And I'd like to say the way that we view it in my office is that the First Amendment is the toolbox for all other freedoms. Basically, there's a reason why the First Amendment freedoms are in the First Amendment, not the others. If anything goes wrong in the remaining amendments or anywhere else, as long as you have the freedoms guaranteed to you in the First Amendment, you can tackle and fix, hopefully, the defects that go awry in the other amendments. So we are First Amendment first in the Franks office. The NRB have rightful reason to believe that the new media companies are not, in all cases, permitting them equal access to the most cutting-edge communication tools available. Ironically, perhaps, the argument seems to be that the very First Amendment freedoms that permitted these companies to come into being and to flourish, and the very freedoms they sell and nurture are, in isolated incidents, suffering under their watch. For a full review of these arguments and incidents, I commend to your reading the September 15, 2011 report of the John Milton Project for Religious Free Speech. I read the entire report myself. This is a summary of viewpoint discrimination in the context of new media, and I'll confess to you that I was completely unaware of 90% of the events chronicled in this report. It was eye-opening, and I'm a person who tries to keep up on exactly these issues. In a nutshell, vague speech codes have been adopted by most new media, and certain groups appear to be targeted for selective enforcement. In most contexts, this selective treatment would be considered discrimination on the basis of religion. But in the context of the private sector, the rights and remedies are decidedly unclear. What to do? It is the position of most decision makers on Capitol Hill that new media companies are private actors and that government has a very limited role, if any, in creating policy for new media. After all, would you prefer to trust the government to be any more fair than the private sector? Exhibit A is the fairness doctrine. As a conservative Republican, I certainly err on the side of keeping the private sector free of government intrusion for many reasons. But the concerns of the NRB are well-founded and in need of discussion. Let me give you some examples. In my position on the Hill, I'm constantly being approached by people who feel that they're not getting a fair hearing or fair treatment by new media. For example, a couple years ago, a production company came to several senior staffers on the Hill to complain that Google was pulling pro-life videos off the web because they were, quote, objectionable. Turns out the videos were basically black screens with white letters that were the transcription of actual and embarrassing statements from Planned Parenthood employees. I began to wonder, why is new media getting into the censorship business? Censorship is un-American, and furthermore, it's not sexy. I mean, since when is it part of the cutting-edge modern tech culture to tell other people what opinions they will hold, what they will say and do? It seems that that only applies to certain people, and not to everyone equally. At the end of the day, however, I was not convinced that there was a congressional role for solving this problem. Consider a second example. Just this morning, congressional staff received an invitation, and I have the printout here, the email, from the Foundation for Defense of Democracies for an event entitled, quote, Facebook Fatwa, Saudi Clerics and the Threat of Social Media Radicalization. The invitation suggests that perhaps these online fatwas promote violence, which would be an easy argument to make, sometimes against American and American interests. What would we expect the American new media to do with this problem, especially where the call to violence is also classified by some as religious expression? What if national security issues were at stake? Now, I'm just giving you a very, very broad sketch of what the issues are, and I'm telling you that we don't have the answers to these problems. I think there is a lot of division. No one has a clear consensus on what the rights, duties, and privileges of all the parties concerned are. And I don't tell you that I have all the answers. And so I'm looking forward to hearing what our esteemed panelists have to say today and hoping that they can give us some guidance as we move forward in addressing some of these as yet still developing legal and policy issues. Thank you.
Thank you very much, Jackie. Appreciate that. I now get to introduce my boss, so I need to do a good job of that. But he actually told me to keep it really short before this. So let me just introduce Dr. Frank Wright. He's the president and CEO of the National Religious Broadcasters. He's been in that position for the last 10 years and has been here on Capitol Hill for the past 17 years. He's also an elder in the Presbyterian Church of America, and we're very thankful he's here to share some opening thoughts before the panel. Thank you, Dr. Wright.
Well, Jackie's done a fine job of setting the stage for our panel, and Craig is going to come up speak momentarily in establishing perhaps a framework for understanding this issue. But let me give you take two steps back, a little broader perspective perhaps about how NRB looks at this particular issue in relation to so many other things that we deal with. It's probably worth noting that the legal and regulatory landscape regarding speech, at least as it relates to electronic media, is a pretty muddled place in our day. Free over-the-air broadcast media is regulated largely by the Communications Act of 1934 and all of its children by amendment. The Act, however, does not apply to cable and satellite, which are subscription services and operate under a different regulatory regime. And the Internet itself, of course, is an electronic media space that is largely undefined, both from a legal and a regulatory standpoint, even though the Commission has exercised some authority over the Internet through its net neutrality proceeding. Overlaying all this uncertainty is something that I think Jackie alluded to, and that is that there are contemporary efforts to criminalize certain speech, so-called hate speech. In the community of Christian media professionals, we find a particular irony in some of these efforts. And by that I mean this. As many of you know, Thomas Jefferson's letter to the Danbury Baptist Association in 1802 had an enormous impact on religious discourse in the public square, as Jefferson's notion of a great wall of separation between church and state was incorporated into Supreme Court jurisprudence over time. Yet in that same letter, Jefferson declaimed, and I quote, that the legitimate powers of government reach actions only, not opinions. Now that aspect of the letter is seldom, if ever, referred to. But for the first time in our history, with the passage of a federal hate crime statute, we have a federal law that can and may criminalize ideas, many of them religious ideas. To this point in our brief national history, most of the significant threats to speech that we have suffered under have been government-related restrictions. But that, of course, has changed in our day and is the subject of this gathering, with the dramatic expansion of the electronic media marketplace, dominated, and rightly so, by private enterprise. This is all coming to a dramatic change. Today, Comcast, DirecTV, and the Dish Network, three publicly traded media entities, largely control television media access for 56 million households. Should they attempt to shape the marketplace of ideas by imposing their own sense of what speech is appropriate or inappropriate, just these three media gatekeepers would impact 75 million Americans. Now that's the television media marketplace. And of course the scale and the scope of Internet access today dwarfs the TV viewing audience, which brings us to our topic today. The emergence of these powerful and even dominant Internet gatekeepers is beginning to threaten free speech and the free exercise of religion in new and disturbing ways. In a day when general access to the so-called marketplace of ideas has never been greater, unfettered access to otherwise lawful speech is coming under significant duress, and this by non-government entities. These non-government entities are, in most circumstances at least, not bound by the free speech protections enabled in our Bill of Rights. And therein lies the great question: what is the future of true liberty in a new media age? And having said that, let me turn to our NRB Senior Vice President and General Counsel, Craig Parshall, to establish a framework for the panel that we're so blessed to have with us here today. Craig.
Thank you, Doctor. A couple of thank yous. First of all, to Dr. Frank Wright for his visionary leadership at NRB, because without that, the John Milton Project for Religious Free Speech would not have happened. We found ourselves in a unique position. In commerce, you always want to be the first with the best mousetrap. And when you find yourself in that position, you find yourself in a position of being a monopoly. And as Justice Scalia reminded us in a recent antitrust case, having a monopoly is not illegal. It's what you do with that monopoly, whether you commit anti-competitive conduct, that makes it illegal. But every business really wants to corner the market. Well, I find, humbly speaking, our organization cornering a market, but no one knows there is a market or a problem. And that's what we're trying to get the word out. In fact, Jackie Pick and I had a conversation about this a couple minutes ago. And that is the vast majority of Americans, if they knew of the problem, would demand a solution. And I think they'd be on the side of free speech values and would ask these new media giants to solve the problem and do it quickly. So I think we thank the esteemed panel for their ideas today, as well as each of you from media and Hill offices. and Washington, D.C. policy groups to help us work out a solution and then let the people in the United States know that we've worked it out and that free speech and free enterprise are going to both prevail. 2 years ago, about 2.5 years ago, we started the John Milton Project. At that time, we were dealing with a theory. The theory was, as we reviewed the landscape of the new media, the theory was that with a few huge, monolithic, billion-dollar giants who have quickly ascended to the position of tremendous market power over new media platforms, we felt there was a potential for anti-Christian, anti-religious, and anti-free speech censorship, viewpoint censorship, taking place on these media platforms. But we didn't have a lot of anecdotal evidence to support that, only that theory. And then, lo and behold, Apple was kind enough to provide us with Exhibit A. A few months after we launched this investigation, Apple banned the Manhattan Declaration, a document of Judeo-Christian principles, some of which dealing with the issue and definition of family and religious liberty. Nothing very radical, all traditional and very orthodox statements of Judeo-Christian morality and belief. But when a group of gay rights activists sent petitions electronically to Apple, Apple decided that they would take that app on their iTunes App Store, which had been approved previously, the Manhattan Declaration, Charles Colson, co-founder of that, and decided to take it off the iTunes platform. It was just a couple months later that they then did the same thing to Exodus International, which is a well-known, long-standing Christian ministry that deals with folks in a gay lifestyle who want some encouragement, some information about coming out of a gay lifestyle. Again, nothing very radical there. Then, as we studied other platforms like Google, we became aware of the fact that Google over in China was really complicit for quite a long time with China's anti-viewpoint censorship. Some of the ideas censored off the Google platform in China were religious in nature. There were certain religious buzzwords that were prohibited on Chinese websites. Then Google saw the light and decided that they would exit that cooperative venture with China. But at the same time, Google was banning a pro-life Christian ad on its search engine in England that resulted in litigation over there. They also decided last year that they would take their phenomenal web tool called Google for Nonprofits, which was designed to encourage and assist web development for nonprofit organizations, and they would limit it strictly to secular nonprofits because religious ones simply would raise too much controversy. Now, I'm happy to announce that at least according to media reports, Google again has seen the light and has changed that policy to include religious organizations and churches and houses of worship as beneficiaries of that web tool. So we commend them for that. But the problem that we documented in our report, True Liberty in a New Media Age, and each of you have a copy of that report in your folder today, has not ceased since we had our press club event last September. In fact, just this week, Rabbi Yehuda Levin had a YouTube series of remarks dealing with the gay rights agenda and his feelings about it as a rabbi, an Orthodox rabbi, stripped off of the YouTube platform. In fact, if you go to his remarks, his alternate commencement address, he called it, to Liberty University, which simply recently had their commencement address, you will find a poster with a rather ugly symbol of a frowning face saying, sorry, but this has been removed because it violates our hate speech policy. We'll talk about that in a couple minutes. But what we found is not just practices of censorship, but in reality, something more insidious than that, and that is that the policies, the written policies of the new media companies, Facebook, Google, Apple, large internet service providers, AT&T, Verizon, Comcast, Yahoo, Amazon, you name it, they all seem to have the same written user policies. And each one of them, every one of them that we analyzed, prohibits what they call hate speech, though they haven't defined that phrase very well, mainly because it is undefinable in terms that are consistent with free speech values. And most of us here know that hate speech as a club, as a wedge, as a sword, has been effectively used to silence simply viewpoints that are deemed to be politically incorrect. Now, we're not talking about incitement to violence. We're talking about statements that people find uncomfortable in today's modern climate of opinion. But more particularly, in addition to the hate speech prohibitions in every one of the new media platforms that we took a look at, we also find some particular prohibitions that we found troublesome. For instance, Facebook, which bans, quote, politically religious agendas, something I can't begin to understand. It's somewhat of a mixed metaphor, but I think what they mean is if you apply your faith to the current issues of the day, you'll have your posting stripped from Facebook. Then there's Apple, which bans any religious content. If it ceases to become more educational and informational, quote unquote, but more, quote, inflammatory, again, undefined terms. Then in Google, we have the directive in their user service agreements that they reserve the right to ban or prohibit any content that is directed against a group or organization that criticizes the religious beliefs of that group or organization. Now, none of that seems to be very consistent with what we believe to be the robust guarantees of the First Amendment. But again, as Jackie Pick has pointed out, and our panelists will all agree, First Amendment doesn't apply, by and large, to the actions of private companies, new media companies included, hence the dilemma that we face today. Now, a little bit of history, by the way, as Justice Holmes reminded us, that an ounce of history is worth a page of logic, and so we go back and take a look at Alexis de Tocqueville, who came over to the United States from France in the mid-1800s, to investigate the phenomenal rise and success of this brand new republic called America. And he found a series of causes or contributing factors that led, in his opinion, to our success as a nation. And there were so many that he compiled them in a well-known treatise called Democracy in America. But I'm going to pick two of them because they were prominently mentioned, and I think they relate exactly to our discussion today. One was the freedom of religious viewpoint in the early 1800s in America. He indicated that Americans, quote, religious zeal is perpetually warmed in the United States by the fires of patriotism. He also went on to note that the concept of religious liberty in the minds of the average American that he met and talked to and observed in the mid-1800s considered religious liberty inexorably intertwined with the concept of civil liberty, and that they could not think of freedom without thinking of religious viewpoint freedom as well. So then we have that element of our discussion today. But he also went on to say that America had risen to phenomenal success in great part because of its innovation and commercial boldness. He pointed out, and I didn't know this until I went back and brushed off my copy of Democracy in America, that at that time, de Tocqueville said that the United States was the second largest maritime industry in the world, and we had only existed as in a few decades as a fledgling nation. He also pointed out that in spite of what he described as insurmountable barriers to our developing ourselves as a manufacturing nation, that our manufacturing industries were making leaps and bounds on almost a daily basis. So free enterprise was part of the fuel that fueled the engine of our successful republic. So hence the stage setting today, how do we reconcile the tremendously important foundational right of free enterprise with the tremendous and important values of free speech embedded in our First Amendment, and I think part and parcel of what makes us great as a nation. So with that, I'm going to turn the moderated panel over to Mr. Greg Baylor. I've had the privilege of knowing Greg for a number of years. He's currently the senior counsel with Alliance Defense Fund in Washington, D.C., in his D.C. office. During his 22-year legal career, Greg has litigated scores of religious liberty cases in state and federal courts across the country. He is a religious liberty consultant for the Council on Christian Colleges and Universities. He graduated from Duke University School of Law in 1990, and thereafter clerked for Judge Jerry Smith of the U.S. Court of Appeals for the Fifth Circuit in Houston, Texas. He also practiced for a period of time with two very notable law firms in Washington, D.C., one Fulbright and Jaworski, in also Seyfarth and Shaw in Washington, D.C., and he also participated as one of the legal counsel for Christian Legal Society's Center for Law and Religious Freedom. It's a tremendous privilege for me to welcome Mr. Greg Baylor.
Well, Well, thank you, Craig, for that introduction, and thank you for the opportunity to moderate this panel. My first task is to introduce the remaining panelists. I'm going to start with the Honorable Robert M. McDowell. He is a Commissioner of the Federal Communications Commission. He was first appointed to a seat on the FCC by President George W. Bush and unanimously confirmed by the Senate in 2006. When he was reappointed to the Commission on June 2, 2009, Commissioner McDowell became the first Republican to be appointed to an independent agency by President Barack Obama. He was unanimously confirmed by the Senate on June 25 of 2009. Now, during his time at the FCC, Commissioner McDowell has worked to help consumers in the communications marketplace to enjoy the benefits of more choices, lower prices, and useful innovations through increased competition. Creating opportunities for the construction of new delivery platforms that will bring about such competition has been one of his top priorities. He brings with him to the FCC 16 years of private sector experience, and I can't stop without mentioning that he's a 1985 graduate of Duke University. And unfortunately, you weren't there. Pardon? That's a step in the right direction. He wasn't there long enough for Coach K to bring his first team to the Final Four the following year. At the end of our table there is my friend Kelly Shackelford, who is president and CEO of the Liberty Institute in Texas. Kelly is a constitutional scholar. He has argued cases before the U.S. and Texas Supreme Courts. He's testified before the U.S. Congress and before the Texas legislature. He has won 3 landmark First Amendment cases and religious liberty cases just in the past couple of years. He was recently named one of the 25 greatest Texas lawyers in the past quarter century by the Texas Lawyer magazine, and he received an award from my previous organization, the Christian Legal Society, the prestigious William Bentley Ball Award for Life and Religious Freedom Defense, in recognition of his leadership and pioneering work protecting religious freedom. Also on our panel today is Ryan T. Anderson. He is the Heritage Foundation's William E. Simon Fellow in Religion and a Free Society at the DeVos Center for Religion and Civil Society. Mr. Anderson researches and writes about justice and moral principles in economic thought, healthcare, and education. He also possesses expertise in bioethics, marriage law and public policy, religious liberty, and natural law theory. Mr.